I'm sure many of you have looked at and seen this new app called Threads, which is just a subset of Meta, which is the parent company of Instagram, Facebook, and other subsidiary apps. Threads has made a lot of rounds on social media, and it has actually caught the attention of Twitter, which is threatening to sue Meta for being a copycat. So in today's video, we're going to discuss a number of things concerning copyright, patent, and whether indeed we can see Twitter having a class action or a lawsuit against Threads. In today's video, we're going to discuss all of these things, and we're going to have a very special guest who is an expert in intellectual property rights, patent laws, and who is going to break down for us and see whether indeed Twitter has any lawsuit or any further claim concerning Threads. So let's go. Hi everyone, welcome back to Simply Legal. And today's video is a bit unique because personally I love intellectual property rights, and this battle between Elon Musk and Mark Zuckerberg really caught my attention, especially the fact that I had a legal mobile app called Farmeron, which connects lawyers and people together. So in this case we have Threads, which is a subset of Instagram, versus Twitter. Now, as we all know, Twitter is owned by Elon Musk, and Elon Musk is now claiming that Mark Zuckerberg, who owns Meta, which the new app Threads is under, copied Twitter, and he's going ahead to that Zuckerberg hired former Twitter employees, and I think we're going to discuss all of that as we go on. Now, I have a very special guest. He is my former classmate, and he's a very good intellectual property rights lawyer. He's a specialist in patent rights, copyrights, and the rest. Here with me, I have Mr. Kanso Kaja Timothy, and Kanso, I think he'll again reintroduce himself, but just a brief statement about him. He's one of the most bright lawyers I've ever known. He was the top of our class, or he was among the top students in our class from our first year to our fourth year, and I think he chose the right field. That's why I brought him onto the plat to discuss about this issue. So, Kanso, the floor is yours.
Yes.
People want to hear from you.
Thanks for having me. My name is Timothy Kaja. I'm an associate at KT Advocates, which is a lead tech-based law firm in the region, that is East Africa, and we're trying to go global. We are partners or members of Alliot Global, which is an international agency that connects law firms and accounting firms across the globe. And I'm very glad to be here.
Wow. Okay. Personally, I've interacted with him so many times, and I've also interacted with KT Advocates, which is one of actually the top law firms we have in Uganda. I love what they do in terms of tech and legal tech, basically, the things that I'm largely into. So me and Kaja, we share a lot in common, especially our love for technology. Now, that's beside the point. Kanso, I'm sure you've been hearing about this battle between Elon Musk and Zuckerberg. The viewers want to know, because this has been something specially requested by the people, especially on Twitter. They want to know whether Twitter has a lawsuit against Threads. Is there even a cause of action? People want to understand these things in the best way possible. So you could break down for us.
Yes, thank you for that. Maybe just to give a background of how this technology space really works. Many a times, we have developers who create many of these super apps that go on to become unicorns. But from the start, their goal is to really set it off. So they want to develop something from scratch or from nothing, then grow it into a unicorn, have investors come on board, and then when the takeover may be full, that means that someone comes in and buys you off completely, or may buy you off and then maybe leaves you with a certain number of shares. They just create what we call share pools. These share pools could be employee share pools for those who work in the company to keep them motivated, founder share pools for those who really created the app, because they are the brainchilds of the app. It's so that when you keep them, then the chances are high that the app will grow. And then besides them, they are what we call the investors who bring in the money. So you should look at these unicorns as something that it is, from the start, it's made for someone to take it over. So it's not alien practice that you see Facebook growing or buying other apps. Some actually are bought off to either be subsidiaries of their known apps, or even just to kill competition. If someone creates an app that is similar to Facebook and is getting traction maybe in Southeastern Asia, people are adopting Facebook for it, then you might buy it to keep it as your subset in Southeastern Asia. Or you might buy it and just kill it off, because the law, once you own something, permits you not only to use but also to abuse. So if I buy a shirt, I may put it on tomorrow, or I may burn it, it's mine. So that is the practice that has been at the forefront of at how Meta has been run, from when it had Facebook and to these many apps that it has created, and going into even the metaverse. All that is buying is just that if you see some label it with a theme that if someone has created, why reinvent the wheel? So if someone has something nice, why should I pay people to think about something nice? I'll just go and buy out the one who has bought something nice. Why? Because they create these apps to be bought largely. So it's hard that you find someone who creates an app and their target is hold onto it forever. At least minimally they'll create the app and let's sell off part of the shares so that they can grow the app. So Facebook has been doing this over time. It's not news. It's not news in Silicon Valley that Facebook is buying off an app either to add it to its pool set or just to kill it off. So that's just the background. I thought we needed that. So in doing this, there are some apps that similar to the 2009 global downfall in the finance. There are some apps that are too big to be bought. You can't buy Twitter when you're Facebook, unless maybe you're Elon Musk, and then you're adding it onto your list of properties that you may want. But some apps are too big to be bought, depending on at the time, because today what WhatsApp is not what it was some time back. And we've seen apps that run out, could say, of relevancy or traction. So it could be too big to be bought at a given time, but after time it could be too small to be bought, and then can be easily be bought out, either to be killed off or to be bought to grow with it, to try to revamp it. So Twitter is too big to be bought by at least under Meta. It's only maybe the world's richest man who can buy it, and for his own reasons. So if you can remember the trail, that even at some point he was pulling out, and actually still suing the lawyers who convinced him to still continue, go ahead and buy it. So it just gives you an insight of how big Twitter is. So if some app is so good but too big to be bought, what do? You have two options. You can grow your pool of employees to create something similar, or you can buy out the people who created the app, or at least who run the super app, and then make them yours so that they can build for you something similar. Why? I can't buy Twitter, but maybe if Twitter is worth 44 billion, maybe the brain cells behind Twitter may be 100 million. So the business decision is that you go in for the brain cells and leave the app itself because you cannot afford it or it's too risky. Okay. So that's the background where we have, or at least from what we've seen so far, it's the background that we have that when the people at Meta sat down to create something similar to Twitter, aka Threads now, they go into Twitter and begin poaching the brain cells behind Twitter, at least what it is at now, and create something similar, and they name it Threads. So that is the background.
I actually didn't know that background. You know, most of the times the media just portrays on the surface, but they don't actually go in depth. So actually it brings me to my next question. You've made it much clearer. Is it true what the lawyer of Twitter is saying? Spiro? It's called yes. Spiro. Alex Spiro. Spiro is stating that Meta hired out former Twitter employees. Is it true? And is it true that they spilled trade secrets to make the Threads app? And if so, do we see copyright infringement? Do we see them selling out trade secrets in terms of patent?
Now, one question is easier to be answered now. That is, did they go and get former Twitter employees now? That is easier to conclude because there is a track record of the employment history of the people at Threads or now at Meta. And of course, you'll see those who have once at Twitter and now at Meta. So it's easier to conclude. As to whether they sold out the trade secrets of Twitter, that is a whole different ballgame that will need a court of law and an elongated lawsuit to determine. I cannot say from here. But maybe what you may want to know is maybe the third question that goes to the copyright and everything. So here it's something dynamic across the globe. Different jurisdictions choose what they choose to do with their laws as to how to create these technovasions or tech invasions. Now, for where we are based here in Uganda, if you create an app, it's largely coding. So if you need to protect that, you'll need to apply for copyright. That's the law that protects your invasion while in Uganda. If there is a bit of ingenuity than ordinary coding and the effect of what you invent, you can go ahead and apply for what we call a utility model. When you cross the Atlantic and go to the States, or maybe when you cross over the Red Sea to Europe, some jurisdictions permit that once you have something like that, you can actually patent it. So patenting might be applicable in US and Europe, but it's not here in Uganda. So in Uganda you can't. But nonetheless, what is common between these two systems of technovation protection is that in both scenarios you'll need to disclose what you have, because the spirit between IP protection, IP just stands for intellectual property, is that one, once you bring something, we want to know what you've brought. Second, we want to protect what you've brought. But thirdly, we want the world to benefit from what you've brought. So the third limb is contentious in that for it to be achieved, for the world to benefit from what you've come up with, you have to disclose what it is. So that means that if you create your Twitter, you must tell us how you created Twitter if you want protection. Either copyright or patent, either you are in California, or you're in Kampala or Nairobi.
And how unique it is.
Yes. So you must tell us before we agree. Now, for many innovators, this doesn't make business sense. Why should I spend sleepless nights and then tell you guys, look, I've come up with this? It's not like an art piece. Like when I drew a Mona Lisa tonight, I want the world to know. At least not how I drew it. I may show them, but I want to show the world how I came up with my Mona Lisa. So what is done, the practice is that these tech giants, and the practice that should be done here, even if you're not a tech giant, is that people go under what we call the Trade Secrets Act and keep their inventions as trade secrets and protect them there under the act. That means that if I tell you a secret and like, look, this is my business invention, I've told you that don't disclose this to anyone without my permission, you should know. That's how I protect it. Alternatively, I protect it under non-disclosure agreements. So this is this is contractual. That's why I'm bringing into my company. I'm going to show you how I make my KFC, but please don't tell anyone else. So we say it's contractual. So if you breach that, you breach the contract. And if you spill over my secret, then you've breached the Trade Secrets Act, which Uganda is lucky to have. Not many countries, at least for Uganda's level, do have a similar legal regime. That's how they protect their invasions. That's how they do it. So I haven't gotten the chance to see what NDAs Twitter has. I don't hold out to say
with
so.
its employees.
Yes. I can also not hold out so that I know the secrets that the Twitter team shared with is from my employees. But that's where the gist of the matter is. That whether there was an NDA, the NDA was breached, then the people who breached the NDA and people who aided and abetted them in the breach and benefited from the breach would be liable. If there was a trade secret, the people who breached that secret and the beneficiaries are liable. So that is basically how we protect the IP in many of these technovations. The other thing that that you may look out for is something from common law, which, depending on the state where you are based, you may benefit from it fully. In the US, some states you may not. But if you're from the UK, Uganda, Kenya, Tanzania, South Africa background, it works for you. It's common law. There's a cause of action called tortious interference with employees. That means that you interfere with my employees deliberately to take them away to my peril and to your benefit.
And now in this case we see that, sorry to cut you short, and now in this case we see that that is what Twitter is blaming Threads for.
Exactly.
They're saying that, hey, look, you took away from our former employees and now you've built something similar according to what Twitter looks like.
Yes. That's likely what they're saying, that you have a business structure
Like
that says that if you see anyone good at Twitter, come poach them out. That's what they're saying. And in law, we call that tortious interference with the employees of one.
The viewers are benefiting a lot from you. So, according to you being an IP specialist, someone who is really engrossed in the field, do you see a similarity between the Threads app and the Twitter app? Do you think Twitter is right in stating that, okay, yes, okay, us visually, the users of both these apps, we can see that there is a bit of similarity, but does that hold water in regards to Twitter threatening to take on Meta?
Yes, firstly, I won't hold out that I've used the Threads app because I'm very, very slow on which apps I bring on board because of maybe practically the time that I have to spend on social media. Cut it down, so I haven't used that one yet. But at least I've read from experiences from those who have used it for that purpose. But what I want to guide the viewers on is that intellectual property protects not the idea, but your creation from the idea, how you execute your idea. So you may have the same idea, whether you want to create a e-hailing services such as SafeBorder or Bolt or Uber, no problem. That's why there is Uber, there is Bolt, there is SafeBorder,
Uber border.
there is everything is there because that's the idea. That's not protected because, like I said, IP has 3 limbs, and the third limb is that the public should benefit. So for it benefiting means that you cannot cut off an idea. Ideas should flow. What changes is the execution. And the target is that he or she who executes the idea better gets more customers.
Actually, I remember looking at the Copyright Act. Is it Section 5 or Section 6? Copyright protects expression of the idea.
Yes.
So even if Bolt came and sued SafeBorder for using their model, SafeBorder will say, but look, we all have the same idea, but I implemented it faster. Or I have a better business model than yours.
Exactly.
So I think that's okay, according to my analysis, that is the issue that Twitter has. I think they're grasping through straws. Yes, there's some similarity between Twitter and Threads, but I mean, if Threads exists and people are like, because I think what really hurt them was the users, because they attracted about 10 million users. In hours, it was a good number of users. So I think maybe they were trying to maybe pull the plug on their operation. I don't know. What do you think?
Yes, of course, from a business point of view, you could see that you know a computer who's counting millions hours after release, and it came at a point where you could say, I want to blame the world's richest man, but maybe for his fault, Elon Musk was putting in what you could say unjust restriction on the use of Twitter. I think even a weekend before, many people were running to Trump's Truth Social because the limitations on the use of Twitter and the freedom of the users was being cut out by the day, and this seemed to be coming too fast than what the users could take. So if that finds if Threads finds you at a place where you're disappointing your users, then you're vulnerable.
That's why many people are running to
Threads. Because if you say, okay, your blue tick is gone, people swallow.
And you now have to pay for the blue tick.
Then you cannot do this, and then you limit their views. I don't know where that came from, but
actually, I've noticed it on my tweets also.
That someone has limited views, and for him or her to view more, they have to pay. That is, I don't want to, like I said, I don't want to blame the world's richest man That is a ridiculous and business point of view, that I should limit my users, because they, whether it's YouTube, Facebook, and everything, their main target is to keep you on the app for as long as possible. That's why they designed the algorithm.
Perfect. You've described exactly what YouTube is. This just to digress a bit. The whole point of now, like YouTube, is to keep audience retention.
Exactly.
As long as you can keep someone on your video, that's why they'll keep serving it out. The algorithm even looks at, they will even ask you questions to other viewers. Are you enjoying this video? How much? They put even smiley emojis. So if someone keeps saying, oh yeah, I love it, it's inspirational, you keep serving it out to more and more viewers. So many people are enjoying the Threads app, but most people have been hearing about the possible lawsuits. Maybe you could outline for us what actions could Twitter sue Threads for? Is it for breaching of NDAs, or we're looking at the possible hypothetical? Is it for breaching of laws of NDAs? Is it for giving out trade secrets? Is it for copying the app? Okay, that one already described it, but the viewers would want to know some more light about it. Is if I got the same navy blue suit as you, the same tie and everything, can you sue me over that under copyright? People want to, because we see many ideas of maybe someone can blame Eddie Kenzo for stealing his beat, or they can sue Amapiano. Amapiano is very common in today. So if a Ugandan incorporates Amapiano in their, can the South African original owner of Amapiano sue?
Now, from the last question, music is a bit different from you say the code behind technology, but they all follow something that we call the substantiality test. Whether someone has copied you substantially, that someone can actually, even a user can easily say that, even if I'm putting on, maybe even if I'm listening to let's say I'm listening from the music from South Africa, it's no difference from one in Uganda. Like, it's so substantial that I just know that this is just a copy paste of the other one. So if, now that is hard, and I don't know how, but what they prove, if the thread's code is substantially the same as the code for Twitter, then there is a potential claim copyright infringement, whether or not the copyright is registered, because copyright, like you may want to know, is not subject to any registration. The moment you create anything that is copyright protectable, is protected automatically. So if you find out that maybe the beat in one song is 80% the beat in the other, then you consider that there's infringement. You find that the code behind Threads is 80% the code behind Twitter, they have a case for copyright. But we are yet to get there, and I doubt Meta would be that dumb.
I also don't think so.
Yes, I doubt, but we'll see.
Because Zuckerberg has been in this thing for a very long time.
Exactly.
And I noticed that one of the strong suits that that Threads has, that Zuckerberg said, is that when we're making a Threads app, anyone can just be able to copy all their data and information from their Instagram platform. So they showed a lot of differentiation between Threads and Twitter, because they knew Elon Musk was going to come out and sue, and threaten to sue. So I think those are basically the questions people wanted to know about. They just want to know, what is the possibility of maybe Threads also counter suing, or what possible defenses can Threads have against a lawsuit from Twitter?
Maybe just to reiterate from the last question, the possible cause of action are copyright that we mentioned, if there's substantial copy paste. Secondly is breach of trade secrets, if any, and then NDAs, if any, because we don't know what is there, but we expect them to have it, and then tortious interference with employees. Now, from a Threads point of view, of course, your first defense would be, if there is anything in line of the copyright, taking the copyright route, is that this thing is not
copyright protected.
No, there was no substantial copy paste. If there was copy paste, it's not substantial.
That's what I also think.
Yeah, that you could say that maybe, because if we have the same same thing, maybe 20% is the same. It's not substantial.
It needs to be like 75% and above.
It depends on the wisdom of the judge, but they'll like at least something above 60. Yeah, they'll like, but it depends on the wisdom of the judge. There's no hard and fast rule. But if there's that, then they'll say it's not substantial. And of course, if then for 30 years interference of employees, you could say that you could now have, because interference means that Meta goes and looks out for someone. But if someone looks out for Meta, then it's not 30 years interference, because the guy looked out for me. So
he came willingly.
Yeah, came willingly. I wasn't
That's
really.
a very good point.
I didn't poach them out. So, but that depends on the facts at hand. In this technology world, you can easily rub and wash many things. So that would be the second one. Now, if they had no NDA, you can't say that I breached anything. But if there's an NDA, it's hard to run out of it. If you breach an NDA and it's black and white, then you breach an NDA. Unless when there is no NDA, or when some NDAs are time limited. So maybe the time has run out, or because that maybe what you shared was not covered by the scope of the NDA. So there it's tricky. But if it's there, chances are high that you have no defense. Then the last one for trade secrets is really saying that maybe this secret was in the open in the first place. Saying that, look guys, everyone knows how you do Twitter, which I doubt. But if you think from a tech point of view that everyone knows that it was public knowledge, so I cannot really, because if I know that the colors of the Ugandan flag are black, yellow, red, you can know that I've given any trade secret that the colors of the Ugandan flag are black, yellow, red, because that's public knowledge. So you can say that.
It's not really a secret.
Yeah, it's not a secret. It doesn't qualify. It doesn't qualify as a trade secret. So that's what you could argue, or say that really maybe you did not tell me, because trade secret requires someone to be cautioned that look, what I'm sharing with you now is a trade secret protected by law. Don't share with a third party unless I consent you to do so. So if there wasn't really a proper layout of that, you could say that you're not protected by any trade secret, or there was no secret at all.
So the whole point, I think what the viewers can get from this is that everyone's ideas should be protected, either via utility model, or copyright,
or a patent, depending on why.
Trade secrets. Because I understand KFC actually has they're protected under trade secrets.
Exactly, because they can't tell us what they use.
Their recipes. Okay. Yeah, I think basically that's what the viewers wanted to know. Can people's favorite app, Twitter, where they can express their views, okay, now because of Elon Musk, it's limited. But can people's favorite app, Twitter, beat Threads, Meta in brackets, in a lawsuit? Even me, this was actually. I wanted to be as objective as possible. Do they have a case against Meta, or can actually Meta counter sue, or do they have good defenses? Because just how much have they copied, and if they copied, did they really copy? How much did they really copy? Are they protected? So people need to gain their knowledge on this. One last question, and this you answer to the viewers while looking at the camera. What is the best advice you can give people? Because we have so many young budding innovators. We have other old people who have ideas that they have been wanting to implement for years. How best can they avoid being in a situation like Threads? If they come up with a new app and it's similar to another one, how can they protect themselves, and with which particular model can they protect themselves under, or which ones are available for them?
Yes, to the viewers out there, especially the innovators, if you come up with something, like I said, in Uganda you cannot get patents for starters. But what you create, with or without registration, becomes copyright protectable. So the business proper decision that favors your business and your invention is that you did not actually apply for a patent or a copyright, because then you will need to disclose. So then what can you do? Because I said you did not. What you need to know is, one, the moment you create something, the moment you code something, it's protected as copyright protectable. No need to register. Don't disclose. Don't tell us. But if you don't disclose how do you operate, make sure that before you share your idea with anyone, especially those who you're looking out to fund you, have them sign non-disclosure agreements with you. Let them sign these NDAs, and these NDAs, if you cannot find, don't just run off the internet and get anything from the internet and think it's an NDA, or don't just run to ChatGPT. It will give you whatever it can give you. And those who use the ChatGPT, what I can always tell them that the farther you are from USA, Washington, or Silicon Valley, the more chance that it will give you something vague. So don't be in Mukono, Ginger, and then run to ChatGPT to do an NDA. Get a good lawyer. Can find one on Fameron app. Get a good lawyer. Have let him or her craft your NDA for you. Have someone sign it before you disclose. Then thirdly, before you're sharing, even with or without the NDA, with anyone, or you're being on a co-inventor, or you're sharing in a classroom or anywhere, let people know that what you're sharing with them is a trade secret, and that they're bound by law not to share it with any other third party except with your express consent in writing. Don't send the consent via WhatsApp, or don't make a call and give consent. Your consent should be in writing. That consent and should be, if you do the same thing, go through Fameron, get a good lawyer, should have safety valves to protect your invasion, even when you give out permission for someone to share. So that's what you basically do. Your NDA, trade secret, and know that your whatever you create is copyright protected.
Okay. Thank you so much, Council Kaja. We have really benefited a lot from your information on intellectual property rights. And really, I wanted you, Vopo, to break down this issue of Twitter versus Threads, because many people have been wanting to know about it. Some people are even fearing to download Threads because they want to know that after them using it after 1 week, the US Supreme Court will give a law and say, an order and say that Thread is now banned off Play Store and Apple Store. So thank you so much for joining us on the channel. For those who are new to the channel, hit the subscribe button, hit the notification bell, and please share this video with anyone who is a tech enthusiast, and also for all of us, I think, in today's world, are tech enthusiasts, because we use these apps on a daily basis. I think Threads is a fast growing app, but you need to also understand the legal aspects behind all these things that we use, smartphones, technology, and the likes. Once again, thank you for joining us, Council Kaja.
Thanks for having me.
He's a very, very brilliant intellectual property rights lawyer. If you ever want someone who is very good in IP, technology, you want your trade secrets protected, you don't end up like Threads, who is being sued by Twitter. You also don't end up like Twitter, who is very, is living in anguish now. But he's a very good intellectual property rights lawyer, and you can feel free to use him at any time. He works at KTA Advocates, and it's located in Kampala. Thank you so much for listening to us, and we shall see you next time. Bye.
Bye.